right, good afternoon. Appreciate everyone coming out today. I'd also like to thank the Jefferson County Public Law Library for hosting this event. It's good to be back with you. The last time I was here, I came to speak about the book that Todd mentioned, and I appreciate the invitation to come back. Being on a panel like this reminds me of that old adage about going to play poker in Las Vegas. If you look around at the table and you can't figure out who the mark is, it's you. And so I'm on a panel with a couple of esteemed jurists and a full-fledged professor, not one of us lower adjunct types. So I'm pleased to be here and pleased to make up the difference, as it were. On our topic about the rule of law, one of the more interesting things that I find about the rule of law is that the term does not seem to have a single agreed-upon definition. The American Bar Association says, as Todd mentioned a bit ago, that the rule of law is the idea that no one is above the law, and that it is what ensures the rights of the people to live their lives as freely as possible and to pursue their dreams. A quick look at the ABA's website will show that the organization roughly equates the rule of law with the notion of judicial independence. And there is some truth there. In a republic such as ours, we do not have a king who can do no wrong. Our system of ordered liberty does seek to maximize individual liberty within a social compact by which we structure our civil society. Nobody wants the judges who cave into political pressure and go wherever the winds of popular sentiment may happen to blow them. But even as the ABA's definition is certainly descriptive of a society in which the rule of law is observed, it's perhaps a little under-inclusive as a definition. The rule of law as a concept is quite old, even older than our country, which, as has been mentioned, celebrates its 250th anniversary this year. You can find the concept described, even if not named, in the writings of such luminaries as John Locke, Montesquieu, and Thomas Paine. For example, Thomas Paine wrote in his famous pamphlet, Common Sense, that in America, the law is king. But I'd say the most famous reference to the rule of law, even if that name wasn't used, was penned by John Adams. Adams, as you may know, was, in addition to being our country's second president, also the primary author of the state constitution for his state, our sister Commonwealth of Massachusetts, in 1780. One of the oldest written constitutions that is still in force today. Adams wrote that the very first part, in the very first part of the Massachusetts Constitution, which is called that Constitution's Declaration of Rights, that, quote, in the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them. To the end, it may be a government of laws and not of men. I'd submit that what Adams referred to in the Massachusetts Constitution as a government of laws is what today we are calling the rule of law. And his use of the term sheds some light on the meaning of the rule of law today. First, Adams identifies the rule of law as the reason each of the three branches of government are required to stay in their respective lanes and may not try to exercise the governmental powers rightfully belonging to either of the other branches. In Kentucky, we have the very same concept enshrined in slightly different phrasing in Section 28 of our state constitution. Kentucky lawyers will be familiar with Section 28, which, in the language of the decisions of Kentucky's highest court, is the second barrel of our double-barreled approach to the separation of powers. For Adams, the separation of powers, and specifically the prohibition on one branch commandeering the powers rightfully belonging to the others, is but a means to an end. The end, he wrote, is that the state government may be a government of laws, that is, a government that is subject to the rule of law. In other words, it is the separation of powers that produces the rule of law. A judicial branch that attempts to legislate under the guise of interpretation is therefore equally corrosive to the rule of law as a runaway executive branch that ignores judicial decisions. I'd wager it's particularly fashionable today for attendees at ABA meetings to fret about the latter while perhaps ignoring the former. The second thing Adams references, his reference to the rule of law in the Massachusetts Constitution provides, is a contrast that demonstrates what the rule of law is not. To quote Adams again, the separation of powers is the means to create a government of laws and not of men. So what is a government of men? It is a government in which one person, or perhaps a small group of persons, get to decide what the law will be for the rest of us. It is a government in which, even if we are nominally equal, some people are more equal than others, or in which the whims, policy preferences, and personal opinions of the few outweigh the considered judgment of the many. The rule of law requires the laws to be relatively stable, to apply equally to everybody, to be public and therefore knowable by everyone, to be applied consistently, and to apply certainly. The notion of a government of men is the polar opposite of the rule of law. The rule of law, therefore, is a product of a government structure in which the power of government is diffused between the branches, in which each branch stays in its own lane, and in which the whims and opinions of a favored few do not outweigh the judgment of the people as a whole as expressed through their elected representatives. With the couple minutes that I have left, I'd like to just identify a couple of the modern challenges that now confront the rule of law. The first challenge I'd like to mention to the rule of law is a rising tide of threats and intimidation that are directed at the judiciary. Serious threats against members of the federal judiciary, according to the U.S. Marshal Service, have more than doubled since the year 2020 to over 450 such threats every year. We have seen attempts to kill several U.S. Supreme Court justices. Politicians have threatened judges that they will pay the price for their judicial decisions. Mass protests and demonstrations have been organized at judges' homes to try to intimidate them into ruling one way or another in pending cases. I could go on. At both the state and the federal level, these sorts of threats and intimidation are an affront to the rule of law. They seek, by the actions of a relative few, to trade judicial independence and reasoned decision-making, both hallmarks of the rule of law, for mob rule, intimidation, and judicial decisions born out of fear and self-interest. This undermines stability and the consistent application of the law, without which we do not have the rule of law at all, replacing it with the government of lawless men. To preserve the rule of law, we must reject all forms of such violence, intimidation, and coercion. Finally, we must recognize that all threats to the rule of law do not originate from outside the judicial branch. Sometimes, as we see in the movies, the call is indeed coming from inside the house. When judges interpret our laws in a way that would be completely foreign to a reasonable observer at the time they were enacted, they risk placing themselves and their preferences above the law. When courts remove subjects from legislative debate by constitutionalizing them, they arrogate into themselves a legislative power, as John Adams in our own Section 28 cautioned against. And when judges enact their own policy preferences into law via judicial decision, they encourage legislative gridlock and further governmental dysfunction. In the Federalist number 78, Alexander Hamilton wrote that the judicial branch has neither force nor will, but merely judgment. In part, he was reflecting on the reality that in our system of separated powers, the judiciary has neither the power of the sword, as does the executive, nor the power of the purse, as does the legislative branch. But Hamilton's quote also gives us some insight into the judiciary's role in fostering the rule of law. The judicial branch cannot coerce compliance with its decrees. It must rely on the executive branch to carry out its sentences and to execute the laws consistent with how the courts interpret them. And it must rely on the legislative branch to appropriate the funds needed to implement its own policy preferences. In short, the court's only superpower is the persuasive force of their reasoned judgments. So while we all want and expect our judges to be independent of the other two branches of government, their judgments cannot be so out of phase with the expectations of the other two branches that they come to be viewed as merely political in nature. The rule of law does not mean rule by lawyers, even if those lawyers happen to wear black robes. The rule of law is more than a highly esteemed concept in political theory. It is part of the bedrock of this country and our Commonwealth. All three branches of our government have a role in guarding it, but all three branches have it in them to undermine it as well. Preserving the rule of law, a government of laws and not of men, is one of our highest callings as citizens. We should expect nothing less of ourselves or from those who make, administer, and judge our laws. Thank you again for having me with you here.